how to avoid the first-headed monster, disability, probate, incapacity. Oh no. Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is what to do when an elder refuses to go to a care facility. That's a tough one, folks, right? So today I'll be answering that question. Folks, you may know me as the author of How to Avoid a Four-Headed Monster of Estate Planning and Elder Law that you can pick up at elderlawcare.com or on Amazon. Today's video question is what to do when an elder refuses to go to an elder care facility. Well, first, what is an elder care facility? That could be a skilled nursing facility. That could be memory care. That could be maybe assisted living facility as well. Okay, assisted living facility oftentimes is the initials ALF, assisted living facility. Skilled nursing facility is oftentimes SNF, skilled nursing facility. So when and what can you do if a loved one, an elder, refuses to go to a care facility that is appropriate for their situation? First and foremost, folks, really important to give our elderly loved ones independence, autonomy, freedom in the community, okay? But there are certain circumstances that rise to the level where interested loved ones need to step in and help their senior age in place safely. So that's what I want to talk about here today, folks. There's all different levels of dementia or cognitive impairment. So for example, if your senior loved one has been formally diagnosed with some level of dementia, it typically comes in 3 levels: mild dementia, moderate dementia, severe dementia. Well, you have to look at things in their totality. If someone has mild dementia and they're living at home independently, getting forgetful, they need some basic assistance with what they call activities of daily living, things we need to do to get out of bed in the morning, things like transporting or transferring from a bed to a wheelchair perhaps, or transferring or ambulating, say, to a restroom. So transferring is one ADL, toileting is a second ADL, bathing or showering independently is a third ADL, dressing is a fourth ADL, and we'll say eating is a fifth ADL, or activities of daily living. So as folks age in place, they may need some assistance with one or more of these activities of daily living. But if a loved one has been diagnosed with mild dementia, they may be able to live independently on their own and with some check-ins every day, or maybe some home assistance coming in and things of that nature. However, if the level of cognitive impairment or dementia rises to the level of moderate dementia, that's when you really need to scrutinize their safety. And are they vulnerable in the community? Are they a wanderer? Are they a person who cannot manage their own medications? Are they starting to be a hoarder? Are they wandering throughout the community and not knowing where they're going out in inclement weather, things of that nature? Are they in danger? Are they a fall risk? And are they putting themselves in danger of strangers who might be compromising their finances or taking advantage of them? That's when you really need to step in, and hopefully someone in the family has been previously appointed as a durable power of attorney. I talk about that in our book, and I talk about that at our educational programs quite frequently. I call it the Big 6 disability planning. The time to put those in place, folks, is maybe in the 3rd quarter of life. Now in the 4th quarter of life, if your loved one is starting to show signs of diminished capacity, really important while they still have some lucidity, that they create that Big 6 disability planning to avoid what I call the formal program or the formal process of going to the probate court to petition the probate court. Folks, you want to avoid that process like the plague. And one way to do that is make sure that you or your loved ones create what I call the Big 6 disability planning. And you can Google elder law attorney Patrick Kelleher Big 6 disability planning to learn more how to avoid that formal probate court process of conservatorship and guardianship. But folks, what to do when a loved one, an elder, refuses to go? Folks, again, you have to look at the totality of circumstances, talk to their doctors, talk to other family members, and what is in the best interest of your loved one. If you are a fiduciary appointed attorney-in-fact, agent, power of attorney, or healthcare proxy, now maybe you have legal authority to have your loved one moved from one facility to the other. But folks, if you do not have a durable power of attorney or a healthcare proxy that gives you that legal authority, folks, typically your only option then is to petition the probate court for what they call substituted judgment, formal adjudication in your appointment as conservator to manage your loved one's finances, and guardian to manage your loved one's medical and healthcare affairs. Really, really important, folks, to know that. At the end of the day, it all comes down to safety. If your loved one is vulnerable and completely incapacitated and they're a wanderer and it's dangerous for them to be at home by themselves, then it's really, really important, folks, to step in and take control of the situation in the most loving and compassionate way with using the least intrusive means possible. Folks, I hope this educational video was helpful. If so, please scroll down, post a comment, post a question, because a member of our Elder Law Care team will get back to you as soon as possible. Folks, thanks for joining us today at elderlawcare.com.